Just remain seated. We will come to order. Thank you. Okay. Hope you enjoyed your lunch. Let's talk about the motion for change of venue now. That is next motion number 28. Is that correct? Yeah, 28. Your motion, Ms. Merchant, says that you ask for a change of venue pursuant to 750 and further constitutional provisions, and believe, for the reasons cited in the findings of fact portion of the trial court order of March 27, 2017, that an impartial jury cannot be obtained in Irwin County. It's my understanding the state agrees with that. Is that correct?
I don't agree that causes findings in that order. I think the second problem is where we want to run into problems and get the jury. I don't think that the pretrial publicity has been, although it's been extensive, I don't think it's of such a nature that in and of itself ought to. However,
well, let me make sure then, Miss Merchant, who's going to handle this?
I can, Judge.
Tell me what you're basing it on. Do you believe that the pretrial publicity has just been so extensive that fair jury can't be had? Talking about we don't have jurors here that are objective about it. Tell me what this motion is based on.
Well, specifically, Judge, I think the court's gag order in the case originally preventing the press from covering certain aspects of the case and preventing counsel and parties from discussing the case. Highlights the importance of what has become a national news case for not just the folks in Osceola and Fitzgerald, but people across the world. And the number of reporters here today highlights the coverage that this case is likely to get locally and nationally and across the world. And it's real-time information. Today is different than it was 10 to 12 years ago. Everybody has access to the internet. But people are still here. People still, I'm sure, remember fondly Ms. Grinstead, some of whom were taught by her, some of whom were friends of hers, colleagues. This is a small town community, and our thinking is that for all the reasons that the gag order suggested that there was no way to put this back in the can in this county, that was a sufficient basis under the Sixth Amendment to be entitled to the right to a jury of impartial jurors. Sure. We believe it would be nearly impossible to strike a jury in Irwin County.
Because of pretrial publicity?
And the jurors' knowledge of the case itself.
But of course the question is not whether they have knowledge, it's whether or not they can set aside anything they may have heard outside the courthouse and judge the case based on the evidence presented here in the law that I get, right? I mean, isn't that the question?
It is, Judge, but our concern was that we would have this courtroom full of potential jurors, and every single one of them has some connection to the case. And given the length of the investigation, given the publicity surrounding the case, considering that so many people have formed opinions about the guilt or innocence of various suspects in the case, because of the podcast and other coverage, we will be here for several months trying to find folks who cannot put those opinions aside, we believe. And that it would be easier to strike a jury in a different county outside the I-75 corridor where Ms. Grinstead's face was not put onto billboards asking for information leading to her whereabouts. And that's just our position. I think it's grounded firmly in the Sixth Amendment that we're going to have a real significant challenge finding folks who have not had sufficient contact with the case to be able to put their personal opinion aside.
As to anything, Mr. Bowden?
Judge, I'm very concerned that we do have an issue on being able to qualify sufficient jurors. I guess we could subpoena everybody in the county and bring them in here and exclude 3,000 people. But if we start excluding 3,000 people, then we want somewhere else to try to venture. Once you get outside the confines of Irwin County, then that concern kind of dissipates. Publicity is everywhere. It's not just
Right. In my mind, the publicity issue, I mean, I noticed around here today, the vast majority of the media attention is not from most of it. This is a relatively small courtroom. The public is not overcrowded this room. The media sources are from outside of this area and serve the entire state somehow. The media seems to be here, and those considerations would apply just about anywhere, seems to me. The next question is whether or not there's so many people in this community that have fixed opinions that it would be difficult to select a jury, and without any evidence, I don't see how the court can draw any conclusions about that one way or the other. My research indicates I'm supposed to hold a hearing and hear evidence on why y'all believe the case should be moved. I understand that y'all, at least at this point, stipulated that it would be best. Y'all are smart lawyers. I'm not trying to second guess what y'all agree upon, because I don't expect there'll be a lot that you agree upon in this case. But I think there are certain thresholds that y'all are required to meet, and I'm supposed to find. I don't see how you're in a position to do that today. But I'm not willing to grant the motion based on the prior findings of fact and the party's stipulation at this time. So we'll need to schedule a time to hear that motion. And of course, the burden's going to be on the defense to carry the day on that, with or without the help of the state. Yes, sir.
Judge, I don't object to the hearing, of course. I would cite to the court Morrow versus the state, 272 Georgia 691. It's a 2000 death penalty case in Hall County. And in that case, the parties agreed, and there was no hearing.
I saw that.
And it rocks on some few years, and then the state withdrew its consent, I'm assuming because of the passage of time. And they had a hearing at that point and did not change venue. But I think you can't. You're not required to. So I don't care about hearing one or the other. I'm good with it. But
well, that's what we're going. Yes, sir, Mr. Merchant.
Yeah, just one final thought that may assist us in the process of the short circuit the need for an additional hearing. Perhaps the state and the defense can get together and put together a mutually agreeable juror questionnaire that could be circulated to members of the potential jury pool in Irwin County. And there may not be an issue, and if there isn't, then perhaps we can revisit whether there's even a need for this issue. And if there is a need for the issue, then we can discuss the potential where it could be.
That would certainly help me. I hope y'all can do that. We need to have a special jury questionnaire in this case. So let's next talk about when to send those out, which is of course connected to when we want to set this case to trial. Assuming the case is not, venue is not changed, that we can work out those issues. We've discussed March as a possible time, March or April. What's the state's position about that?
Judge, the only thing I point out to the court is one of the immediate family members of the victim in this case has some upcoming surgery that's probably going to be held in January. So if we could schedule it towards the end of March or April, that would certainly alleviate that issue. They've been trying to wait on the surgery until we were able to schedule a hearing. I waited for a couple months on to schedule that because they wanted to know when we were going to have the jury trial. So again, I'm just saying maybe not the first part of March, but towards the end of March and April, that's just based on that issue.
Y'all okay? End of March, first of April?
I believe so, Judge. And the only issue that I raised before during our call earlier was I may have another case set for trial in April, but we will work around
That long for that case, right?
Yes, please.
How long y'all anticipate, let me start over here, Ms. Hart, how long do you anticipate the trial will last to put up the state's case if you have an educated guess right now?
Just so I'm clear, do you mean including jury selection, Judge?
Yes.
I anticipate including jury selection, we're looking at December.
Okay, you don't believe that as well?
I think
Maybe more if we don't move it out in the trial. Yeah.
Exactly, Judge. I think that will depend on the questionnaire and the outcome of that.
Right. What about the actual presentation of your evidence?
I would anticipate somewhere around 2 weeks to present our evidence, so we can have 2 weeks to present the state's evidence.
All right. All right, I'm going to set this case down for trial Monday, April 1st, 2019, begin jury selection. That's down. We'll have to have some further hearings between now and then, and I would love to resolve this venue issue as soon as possible.
So is that something that we could go ahead and schedule a hearing for December?
Yeah, let's do that. Have you got, well, we'll need to have the results of our jury questionnaires. How long do you think it would take y'all to put something together in that regard? Can you do that within 2 weeks?
Yes, sir. You know, we've recently had to do this in a Worth County case.
Right.
And it didn't take much time in that particular case. Obviously, this case, there's a lot more witnesses, there's a lot more details, but I still think 2 weeks would be adequate. Keeping in mind, I think the court was just about to mention this, I do have jury trials next week, but Mr. Dowd will not be in jury trials, so that's certainly something we can accommodate.
Why don't we do this? Why don't we have the state draft, make your initial draft forward to the merchants, and let's take it from there. Let's all of us communicate about it. By conference call or some other method on Monday, December the 10th. Okay?
I have surgery.
I'm sorry, you have surgery that day?
Your Honor, you're also in Worth County that day. I know we've been working around
Well,
that,
what
just so you're
happened?
aware.
Oh, I see. How long are you going to be laid up? Do you know, Mr. Brown? Is that outpatient or
No, I should be back Tuesday.
Tuesday or Wednesday? All right. Let's call it December the 12th, then, that Wednesday, okay? And if we need to adjust that, let us know. Check your schedule. If that's not convenient, let me know. Yes, ma'am.
I'm starting a double homicide murder trial on December 3rd, and it's anticipated to take 3 weeks. That's what the court has specially set that for. So I would just ask that it be on the break.
Listen, I don't want to distract you from a double homicide case.
It's a retrial.
Okay. Well, keep us, I tell you what, why don't we just set it for that Friday? That's the 14th.
14th.
And we can hear it, after, late that afternoon or something like that, after your case is close to the day. All right. We'll have a conference call and we'll be communicating about that. Ms. Ross, how long will you need to have these questionnaires before you can get them out? Can you get them out within a day or two?
Yes, sir.
Okay. All right. What else do we need to discuss before we adjourn?
The only other thing, Judge, would be if we want to go ahead and look at another date as it relates to any other motions that may need to be looked at. I don't know if the court wants to wait until we get until our conference call on the 14th or not, before we try and set that date. But
Well, the big issue to be decided, that a lot of these motions hinge on is the venue.
yes, sir.
So let's just wait. Anything further from the defense? Okay. All right, we'll be adjourned then. Thank you all very much. Have a good day. I'll publish these orders hopefully by Wednesday. Okay.
Actually, I just forget to ask you, the order on the Jackson dinner, you did really want me to prepare that, is that correct?
Well, I'm happy for you to please send the draft to the merchants first, okay?
Thanks, Judge.
Thank y'all. We'll be adjourned. Nice to meet you. Okay, y'all.
Thank you.